Welcome everyone to another MASSP Hot Topic webinar. This one is focusing on LGBTQ plus issues, and we are super lucky to have two of the wonderful attorneys from the Thrun Law firm with us today. So everyone, as you are logging in right now, please just in the chat, go ahead and comment your name, your school district, your position would be great, just so we all know who's with us today. And remember that even if you have to jump off, you will be receiving a recording of this webinar, and you'll also receive a handout that Thrun has provided for us. So we'll get started in just a minute. Just want to give a few people a little bit more time to go ahead and log in. Of course, the huge benefit of being able to join these webinars live is that you do get to ask questions. So we'll get started in just a second. Great to see so many people with us today. I know, some of you in Michigan, we kind of have a 3-week window of when school starts. So for some people, this isn't optimum time. But as I mentioned, I thought, man, this is such a hot topic. Great to be able to get this information to you so that you're starting off the year on the right foot and making sure that we welcome all students in our building and record names properly in our student information systems and all of those things. So just kind of checking out the chat here myself. Nick Angel, welcome. Great to see Steve Clark always with us. Tracy Wilson, MASSP board member. Good to have you with us as well. Rachel Hervey from Washington International. Good to have you with us. Lindsay Costin and Lauren Kaiser. Great to see so many of you. This is an important topic, I know. Lorinda Jonas from Bath Middle School, welcome. Cool. Wow, we are just filling up here. Aaron Romoslawski, one of my favorite people. Great to see you. Hope you're having a great start to the year. All right, we are going to go ahead and get started. I love to start and end these things on time because everybody is busy. So before we really get started, if I haven't met you before, I'm Wendy Zadab, the Executive Director at MASSP. We are going to use the Q&A system to go ahead and pose questions. So the chat is just for, those little chatty things, comments that you might want to make to those who are on the webinar. But if you officially want to ask a question, if you kind of run your scrolling along the bottom of the screen, you'll see the Q&A pop up. That's where you want to put your actual questions. Cristina Patzelt from Thrun is with us, along with Jennifer Starlin. And I understand Jennifer is going to be kind of kicking us off. So that would give Cristina the opportunity to maybe answer questions in the chat and also to bring those forward. And then Jennifer will do the same when Cristina is presenting in the second half. So please use those functions appropriately. As I mentioned earlier, we do have a slide deck and a recording of this. Everybody who's registered will get that email to them, hopefully within 24 hours of us completing today. And there's also going to be an extra handout as well, which will be awesome. We always just remind people that although we do have attorneys that are doing this presentation, it can always be a little different in your district context. So we want to make sure that if you have any questions or, follow up after this, that you talk with your own district legal counsel and kind of process these things with your central office as you work through and make sure that you kind of have the guidance that you need and that you're kind of moving forward with these things with the collective vision of your school district as well. So as mentioned, we have Cristina Patzelt from Thrun Law Firm with us today, along with Jennifer Starlin. Many of you are becoming very familiar with these ladies as they do a fantastic job kind of getting out there around the state to the school districts that use Thrun as their law firm. And for those that maybe don't, you also see them at EdCon and at our AP Summit. And man, I'll tell you, ladies, you guys are just nonstop. So I really appreciate the fact that you made time for MASSP during your height of the busy season. I know you're out in school districts doing presentations and meeting with people on Zoom. So thank you so much for making the time to be with us for this important topic today.
Of course. Thanks, Wendy, and thanks for having us. Always great to present to this group. And I know that this is a hot topic, and it will probably continue to be a hot topic for the foreseeable future. So we're going to get started. You should be able to see my screen now. Okay, I've got the thumbs up. I'm Jennifer Starlin. I'm an attorney from Thrun Law Firm, and we're going to be talking today about LGBTQ plus back to school, things to know, some of the basics. Some of this you've probably seen or heard before, but this is a topic that Cristina and I were very busy with back in 2016, 2017, and it seemed like this was something we got calls on every single day. And then it sort of died down, and I didn't really have any calls on it for several years. Then, towards the end of COVID, we saw a real resurgence in these issues. After talking to some folks over at MDE, they shared that a lot of students had used the stay-at-home orders and the fact that they weren't going to school to transition. So when school resumed, schools had a lot of transgender students that perhaps they didn't initially know were transgender or hadn't previously been identified as transgender. After that, we saw some changes to a lot of our boards and a lot of different ideologies on those boards. And that has also contributed to this debate and this topic. And we wish that we had the magic bullet with the easy answer and we could just tell you what that is right now, and then we can all log off 50 minutes early and you'd have all your problems solved for this year. But unfortunately, I suspect we will probably be talking to many of you as the school year goes. So we'll jump in right now. If you've ever been to a Thrun presentation, you've seen we also have our disclaimer slide. Wendy did a really good job of covering the disclaimers, but yes, we are lawyers and we're talking about the law, but this is not legal advice. And I think this is very true for transgender student issues because this is an evolving area of law. We do expect additional guidance or possibly additional laws coming out on this topic in the future, and the facts usually always matter in these types of cases. So we're going to start with sort of an overview of the legal standards that we have to consider when we're looking at accommodations for transgender students. And we start with the Equal Protection Clause of the 14th Amendment of the U.S. Constitution. And the Equal Protection Clause basically says, if we have laws, they apply to everybody. Nobody's exempt from the law, and there aren't laws that just apply to certain people. Now, the Equal Protection Law, or the Equal Protection Clause, has been used as a vehicle to get some of these lawsuits into federal court. And I've heard a lot of people talk about equal protection in the context of transgender students. Basically, all of the laws should apply to everybody equally. So that's often an argument we see when we have litigation involving transgender students. Now, in Michigan, we also have the Elliott-Larsen Civil Rights Act. The version that's up on the screen includes the recent amendments. Now, these aren't effective yet. They're effective. It will be 91 days after the legislature adjourns for the year, plus another 90 days. So we're probably going to be looking at late spring that these will be effective. But know that the Elliott-Larsen Civil Rights Act was amended to expressly include sexual orientation, gender identity, and gender expression as protected classifications. So you can see we had before religion, race, color, national origin, age, sex, height, weight, familial status, marital status. The sexual orientation, gender identity, or expression, those were added, and that will be effective sometime next year, depending on when the legislature adjourns. I'm guessing probably late May. It will be the effective date of these. Now, in practice, what we'll talk about, this probably won't change how you're operating. And the reason why is that the word sex, or the phrase discrimination based on sex, has long been interpreted in a way that does include sexual orientation, gender identity, gender expression. So the express carve out under Elliott Larson, it does put those out there, but it doesn't probably change a lot of what you're doing. Additionally, many of our schools, they have non-discrimination statements, and you may in your school, that already included sexual orientation, gender identity, gender expression. So it's possible that in your school, you already had that as a classification that's expressly called out. Now, Title VII is a federal law that prohibits discrimination because of sex in employment. So your employer can't discriminate against you because of sex. Title IX, I'm sure you're all well aware of Title IX. Hopefully you were lucky enough to attend one of our 5-hour-long Title IX comprehensive trainings. I'm sure you recall it well if you were on that fun Zoom meeting. And we do have more coming up if people still need to be trained. But Title IX is a federal statute that says that if we accept federal funding, we can't discriminate on the basis of sex in our education programs or activities. So these phrases, on the basis of sex or because of sex, keep those in your mind because we're going to talk about those in a little bit. Now, back in 2016, I said that this was really hot in 16, 17. And you might remember Time Magazine had the cover picture, and it was the toilet paper that was a rainbow, and it talked about the bathroom battles. I mean, this was a really hot topic for about a year and a half. And now it's sort of resurfaced. But back in 2016, Michigan State Board of Education adopted a guidance document for safe and supportive learning environments for lesbian, gay, bisexual, transgender, and questioning students. Now, that document is not binding, it's guidance, as with all guidance that comes from the State Board of Education. But it does include some good tips and some recommendations, including the fact that the student is the best person to determine their own gender identity. When we have students who put pronoun requests or name change requests out there, we should make a good faith effort to address the students by their chosen name or pronouns, regardless of legal name status. There's no law that says a school has to call a student by their legal name. And I would be surprised if there's any school in the state of Michigan that strictly only calls students by their legal names. A lot of people in school called me Jenny. My brother is John, but he always went by Jack. These are, nicknames that a lot of students have, and a lot of students go by middle names. So if we're doing that for cisgender students, then we need to equally do that for transgender students. Now, the State Board of Education's guidance also talks about considering changes to student records. Now, my understanding, I've never been in Power School or the student records systems, but my understanding is that many of them now have a nickname field where you can put in, a preferred name, whether that's just what you're, Jenny instead of Jennifer, or whether it's John instead of Jennifer. So those are, it's my understanding that has become a lot easier for schools to do. Now, I will say, again, it's my understanding that at the state, there are still some hiccups in terms of reporting, both for statewide tests and pupil accounting purposes, because there's not necessarily a way to change that legal name that's attached to the UIC. So that means there will be some manual work required when some of that data is entered. We've advised the state many times over the years that, this is sort of a hiccup, but so far have not seen any change to that system, or I'm, at least as far as I'm aware. Now, remind staff that you may be thinking, or you have very likely heard of FERPA, the Family Educational Rights and Privacy Act, and FERPA protects student record information. You will not have transgender status gender identity, birth name, or sex assigned at birth designated as directory information in your district, which means that staff can't disclose that information to others who don't have an educational reason to know that information. Now, as I already mentioned, there's not a law that requires a school to use a student's legal name, but we should make those efforts to use preferred name and use pronouns consistent with the student's name and gender identity. Now, we're going to talk a little later. Whenever we talk about this, we get questions about staff religious objections, and I see the chat lighting up, though I can't see what's being put in there. We are going to talk a little bit later about what to do when we have a staff member who requests, for purposes of a religious accommodation, not to use a student's preferred name. Christina, did you want to jump in?
Yes. So the employee religious accommodations we're going to touch on. I like 3 different questions here that are all sort of the same question. So I want to just briefly talk about them, which is basically, do we require parent approval to change a name? Or what if a parent requests we don't refer to the child by their chosen name or chosen pronouns? So what do we do where there's either disagreement or maybe the parents don't know?
Mm-hmm. So I think we'll take them one at a time. First of all, if the parents don't know, I think it's very important to figure out why. So let's start with the student and say, why haven't you told your parents? Then you need to have a conversation, or somebody who, maybe a counselor or somebody who is in an appropriate position to do that, should have a conversation with the student about the realities of, if you're using a different name and pronoun at school, that's going to get back to your parents. Because even if the school doesn't tell your parents that you're using a different name, the kid in your class will go home and tell their parents, and it will likely get back to your parents. And I think another piece of that is taking that to its logical conclusion. I mean, how long are the parents not going to know about this? I mean, are they going to be surprised when the kid walks across the stage at graduation and we announce a different name? So talking to the kid about the realities of, if we're going to use a different name, your parents are going to find out. We also don't want to be in the business of keeping secrets from parents, that it will spoil the relationship. Any ability that you had to be a bridge between that kid and their parents as they work through this difficult issue will be extinguished, because trust has been broken. So you don't have to pick up the phone and tattle immediately, but you need to work through with the student why they're not telling their parents. Obviously, if there are abuse concerns, then that may trigger our mandated reporter obligations. But at the end of the day, we want everybody to be on the same page and to see if we can find something that works for everyone, and make sure we keep the parents in the loop once we've identified, what is the hurdle? Why is this kid not willing to tell their parents? If the parent is adamantly opposed to it, I think I would start by figuring out if there's some compromise. I mean, perhaps the parent, perhaps the student and the parent are both agreeable to using a last name. I'll call you by your last name. In terms of pronouns, depending on how many teachers the student has, there may be, the teacher could also just avoid using pronouns. I mean, I think we've all been in that position where you're not exactly sure of somebody's pronouns, and so you just avoid using them altogether. And that might be something where we don't necessarily have to designate. But if we can come to some sort of compromise with the students and the parents, at the end of the day, though, the student is the person who's in the best position to determine their gender identity. And so we should err on the side of being supportive of the student. I know we've talked internally about some strategies to help with that. And something that's come up in our office is, if schools communicate to parents and say, we're here to teach your kid math. And if your kid is going to learn math better, if I call him John instead of Jennifer, then that's in the student's best interest. So, maybe when they hear that message, sometimes that does push the parent over and say, okay, I get it. They're not trying to interfere. They're just trying to put my kid in a supportive learning environment. It's not going to work every time, and there's not a perfect answer. but that's sort of the best path that we have. Christina, did you have any other thoughts on that?
No, I think Jenny's exactly correct. She really summarized. We've had a lot of discussions internally about this, and what it came down to is exactly this sort of step process that Jennifer described. Is if the student, our first question is, has the student told their parents if they come to us with a request for their name? If they have, great, let's involve them. If they're supportive, or even if they're not. If they're not supportive and they have this disagreement, let's try to have a conversation about it. Let's use the State Board of Education guidance because it's written in plain English. It's not in legalese. If you Google SBE, like LGBTQ, the document should come up. So it's something that I know I've had schools use with parents as just a resource to help talk about the subject. Having those conversations with a counselor and a social worker and whoever else, maybe without the student involved at first and then involving the student, can all be really helpful to get everyone on the same page. And that's whether the parents don't know or whether they know and they disagree. And then I agree with Jennifer, if we get to the point where we're really at odds, we don't have a case as of right now that says definitively parents' rights trump students' rights or students' rights trump parents' rights. I'm going to talk at the end a little bit about two cases that did address this issue somewhat with regard to school policies, but they didn't come fully to an answer. And of course, they're not from Michigan, they're not binding. So, they ruled in favor of the students in those cases, but we don't have a definitive answer. So as far as our specific questions, should we require parent approval to use the nickname field? I'd say that one is almost an Equal Protection Act question. If Jennifer were to come to you and say, hey, can you put Jenny in as my nickname field? And you don't require parent approval for that, then you can't require it for a transgender student either, because you have to apply the same standards. Yeah. If you require parent approval, then you can apply the same standard. But if the student is changing names and gender expression and identity, let's try to have a sensitive conversation about that. Parents request, we don't refer to their child by the chosen name or pronouns. We talked about that where they disagree. The other question was, that I answered live in the chat was, does their diploma have to be their legal name? It does not. I want to briefly touch on that. We get questions about, a diploma, it's a legal document. It is not. A diploma is a piece of paper that you issue that a kid can use to prove that they went to school, but it's ceremonial. It is not an official legal document of any kind. Yeah. And then student photo ID. Can we change their name on this, given that it is a legal photo ID? Same thing. I would say, what is your policy on student photo IDs? Do you normally put student nicknames on there, or do you keep students' full names on there? If you keep students' full names on there, and this student has requested, I was Christina, and now I'd like my name on my ID to be William, then we have the conversation about making the change. No law requires you to use the student's legal name on their photo ID. And so making the change is something that we would do that is in support of the transgender student. We would treat it the same way we treat the rest of the conversation about that, where if we've got parents that don't know, we try to bring them in and talk to them about it. If we've got parents that disagree, we're trying to have a conversation about it. Someone asked also, how frequently should a preferred name be asked to change in the student record system? That is a great question that we get a lot. This, I think we've discussed internally, and Jennifer, you can step in if you disagree, but you can put limits on how often a student is asking to change their name. Yeah. Your obligation is to ensure that the kid is at school, learning, and safe. That doesn't mean that we're changing their name every single week or even every month. You can put limits on, okay, we're changing your name right now, and then, we're not going to change it again. Same way, and that's the same rule that you would use with cisgender and transgender students. So it's not going to change. It's not going to be discriminatory for you to put those parameters in place.
Yep. Yeah. And I think we get a lot of questions. We're going to talk about bathrooms in a second. But I've heard the question come in many times about gender fluid students who want to be able to use a different bathroom on any given day. And I think the guidance or the analysis on that is the same thing that Christina just laid out, which is all students are able to access either the boys' bathroom or the girls' bathroom and a single-use one for when they're uncomfortable. You do not have to allow a student to just use all of those. And I'm comfortable saying you can use the single-use bathroom and a bathroom consistent with your gender identity, but you have to commit. Like, are you going to use the boys' bathroom in a single-use bathroom, or are you going to use the girls' bathroom in a single-use bathroom? And there is nothing out there that would support a position that you have to just allow access to any student anytime. Girls' bathroom today, boys' bathroom tomorrow.
Yeah, I think if only I've talked to schools about it, it's almost a safety issue. We need to know if an alarm goes off and we're trying to count heads. Are you in the girls' bathroom or the single user bathroom? Not all the girls' bathrooms, all the boys. We have to look in every bathroom essentially. Question about, is a high school transcript a legal document?
So you can change the student's name on it. I don't know if it's a legal document. I do think it depends on what statute we're looking at. I know it's something that's used to prove attendance, and it's used by colleges, but there's no law that says you're not allowed to change a student's name on their transcript. And if you get that request, usually recommend that you do, because when that student goes off to college or to a trade program or to some other post-graduation learning, you don't want them to be outed, when they apply and have to explain something.
Yep, agreed. And then the last question is, someone said, I would be better off adding a student's preferred name as a nickname versus changing their name in PowerSchool. I think that's gonna be a question for your student information system provider, because, like Jennifer said, I know different student information systems are doing different things. What you want is, where the change in the system is, you want to be able to generate a class list for a sub that has the student's preferred name on it. You want to be able to, if you're sending a letter home to parents, it refers to the student in their preferred name, if that's the discussion that you've had with their family. So you just want to be sure that wherever you're putting it is creating the record that you want. Because what you don't want is a situation I ran into with a school district where they had an OCR complaint about discipline based on disability and discrimination based on disability. And when we pulled the discipline records to send over to OCR, it also turned out, we knew the student was transgender. It turned out one of the teachers who'd been entering discipline had just refused to use the student's preferred name for 3 years. So we had discipline records where it had preferred name, preferred name, preferred name, birth name, preferred name, preferred name, preferred name, birth name. And it's never great to send something to OCR that on its face looks discriminatory.
And I would also add, how the nickname function is used in your student record system is really going to determine whether or not that's enough. Because if everybody who accesses that can see, okay, this kid's transgender, then that's not going to be sufficient, because that's going to out them every single time somebody accesses those records. So I don't know what levels of privacy exist within those student record systems, but that would be something to check, because you wouldn't want every sub to open it up and say, oh, look, this kid, birth name Christina, preferred name William, I know what's going on there. So that would be something to watch for. But if the nickname kind of overrides the legal name, but if you dig a little further, you can find the legal name, then I think that would be something that would be you could do.
That clears all of our questions.
All right. So I'm going to shift gears and talk about bathrooms. The state board's guidance on bathrooms specifically says that every student needs to be safe, that gender neutral bathroom facilities are often the solution that works best for all students, including transgender students. But, and this was back in 2016, current interpretation of federal civil rights laws protect the right of transgender students to use the bathroom consistent with their gender identity if they so choose. So if you have a request from a transgender student to use a gender neutral bathroom, you can grant that request. If you have a request from a transgender student to use a facility consistent with their gender identity, then what OCR and MDCR and the courts have trended towards is saying you would need to allow that student to use that restroom or that facility consistent with gender identity. Couple of cases that we want to touch on. Dodds versus the U.S. Department of Education was a Sixth Circuit case from back in 2016. And in this case, we had an Ohio school, and they had a policy that required students to use bathrooms consistent with their sex assigned at birth, their birth gender. There was an 11-year-old transgender female student who sued the school because she was seeking to use the girls' bathroom. And she had asked and was denied, and so she sued. And there was at the lower federal court level, an injunction ordering the school to allow the student to use the girls' restroom. The Sixth Circuit, whose decisions are binding on Michigan, upheld that injunction, and they said under settled law in this circuit, and this was back in 2016, sex stereotyping based on a person's gender nonconforming behavior is impermissible discrimination. And that's what was happening there. The next year, this was out of the Seventh Circuit, we had another case involving a school. The Seventh Circuit affirmed a preliminary injunction against a school and found that making the transgender boy use either the girls or the gender neutral restrooms would likely succeed on a Title IX and or equal protection claim. And the court said transgender students, by definition, don't conform to sex-based stereotypes of their sex assigned at birth. That's what makes them transgender. So gender stereotyping or requiring somebody to do something inconsistent with their gender nonconforming behavior would violate the law. And the court said there that a policy requiring an individual to use a bathroom that is inconsistent with their gender identity punishes that individual for his or her gender nonconformance, which in turn violates Title IX. And they said providing a gender neutral alternative is not sufficient to relieve the school district from liability, as it is the policy itself which violates the act. Now, fast forward to 2020. There was a lot going on in 2020, a lot of it that we'd like to leave in the past with COVID and all of that fun. But in the midst of all of that, we also had a decision from the U.S. Supreme Court. And the court issued a 6-3 decision on June 15th about Title VII. And remember at the beginning, we talked about Title VII prohibits discrimination based on sex in employment. And Title VII uses the phrase because of sex. And the court said the prohibition against discrimination because of sex does include discrimination based on gender identity and sexual orientation. And the court said it's impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex. And Supreme Court Justice Neil Gorsuch wrote, an employer who fires an individual for being homosexual or transgender fires that person for traits or actions that it would not have questioned in members of a different sex. Therefore, sex plays a necessary and indistinguishable role in the decision, and that's what Title VII forbids. Now, if you think back to those statutes that I read at the beginning, Title VII says we can't discriminate because of sex. Title IX says we can't discriminate based on sex. Really similar language there. So Bostock didn't interpret Title IX. It was a case about an employee, a government employee who worked for, I believe it was a city, or I guess it was a county. And so Title VII applied. It wasn't about a student. But the language in the two statutes is very similar. So we did have the Fourth Circuit shortly after the U.S. Supreme Court's decision say, after the Supreme Court's decision in Bostock, we have little difficulty holding that a bathroom policy precluding a student from using the boys' restrooms consistent with gender identity discriminated against him on the basis of sex. And this is Gavin Grimm, who was the subject of the case. And this is a case that had bounced around the courts going back to about 2016. And in June the following year, June of 21, The Supreme Court rejected the school's appeal to reinstate their bathroom policy. And in August of 21, the school paid was ordered to pay $1.3 million in legal costs to the ACLU for their representation of Grimm. Now, this is a case, like I said, it had lingered for several years. It's gone up and down the court system. In most of those decisions, Gavin Grimm has prevailed. And this is a school that had a policy that said he was not allowed to use the boys' bathroom. Now, Gavin's graduated. He's moved on with his life, but the litigation continued. And actually, one of the lower court decisions specifically said that it wasn't moot because the school continued that policy, and that could have that impact on students in the future. Now, after the Bostock decision, we got a couple of other important updates. The Office for Civil Rights issued a notice of interpretation the following June that said, basically, because the language in Title IX and Title VII is so similar, we will enforce Title IX's prohibition on discrimination based on sex to include discrimination based on sexual orientation or gender identity. And the Michigan Department of Education, specifically issued a statement supporting OCR's statement, and said that they would also interpret it in a similar manner. Now, we got some guidance in June of 21 from OCR and the Department of Justice's Civil Rights decision. Civil Rights Department, and these are examples of incidents that the civil rights team and OCR can investigate. And as you look through that, we have specifically in here the fourth example, an elementary student wants to identify as non-binary, use they, them pronouns. The student's teacher laughs when other students ask if they're a boy or a girl. The teacher tells the class there's only boys or girls, or anyone who thinks otherwise has something wrong with them, and the administrator is not very supportive. We also have an example in here about restroom use. And again, these are all examples of things that if OCR got a complaint, they have said they would investigate. That's worth checking out that document, at least so you know how OCR would interpret certain situations. Now, in 2022, there was some guidance issued by the Biden administration in June of 2021. And that guidance talked about ensuring that transgender individuals at school and work have access to bathrooms, locker rooms, and sports teams. There was an injunction issued by the Eastern District of Tennessee, and that applies in 20 states, but Michigan is not one of those states, which means that guidance can still be enforced in Michigan. And this remains in place until we get some final order or resolution from the Sixth Circuit or from the Supreme Court. So stay tuned on that. And I know we'll also talk a little bit about other things that might be coming down the pipe, including what could be new Title IX regulations that possibly, stay tuned, we're not sure, but possibly will specifically cover some of this. So I will turn this over to Cristina now, unless, Cristina, are there any other questions or anything right now?
Yeah, no questions that have come up right now. But again, please feel free to pop them into the Q&A. I can still see the Q&A. So Jennifer's going to be moving the PowerPoint forward. So I will take a look at the questions and we'll either answer them live or we'll answer all of them live, actually, because Jennifer will be moving the PowerPoint forward. So we won't be able to answer them in the chat, but we'll just answer them live. So I'm going to talk about student privacy, and then we're going to talk about the employee religious accommodation issue that Jennifer mentioned, and we're going to finish off with just sort of like a hot off the presses update of a couple of different things, where things are right now. I'll start, before I get into student privacy, Jennifer's mentioned about the Title IX regulations. We were told by the Department of Education that we would get amendments to these regulations in May of 23. Then that date came and went. And then they said, oh no, now you get them in October of 23. So maybe we'll get them in October of 2023. Who knows? But Jennifer is correct. We do anticipate when these amended regulations come out, they will likely include some regulations addressing transgender student participation in athletics, which is a proposed rule they've put out already for comment on, and then also to more explicitly include gender identity, gender expression, and sexual orientation in the definition of sex. Most, as Jennifer noted, courts and federal agencies already interpret Title IX that way, but this would be putting it into explicit law the way that the Elliott-Larsen Civil Rights Act was amended. So let's talk about student privacy. Okay, so first case that we're going to talk about is a case called Students and Parents for Privacy versus the Department of Ed. This is May of 2016. Just like Jennifer said, this was happening back in 2016. So this is happening in the Northern District of Illinois, the court case there. It's happening against a high school in Illinois, Thomas More Society, the Alliance Defending Freedom, OCR, everybody's involved, all the major players. So in that case, the high school students who were not transgender and their parents formed this group or associated with this group called Students and Parents for Privacy. They filed a lawsuit against the school saying allowing transgender students to use bathrooms that correspond with their gender identity violates our right to privacy, violates our Title IX rights, and is sexual harassment for us. So the court in that decision, they said, no, high school students don't have a constitutional right to share restrooms or locker rooms with transgender, don't have a constitutional right not to share restrooms or locker rooms with transgender students whose sex assigned at birth is different than theirs. So they're saying, no, there's no constitutional right here that you get to have a bathroom without transgender people in it. Then the court also addresses the Title IX issue and says, hey, this also doesn't create a hostile environment. It is not severe, pervasive, or objectively offensive. That's how we defined hostile environment in 2016. It's different now. And that given the privacy protections the school district put in place, in those facilities and alternate facilities available to everyone, not just to the transgender students. So the gender neutral or single user restrooms were available to everyone. They said this doesn't create a hostile environment because they could use a different bathroom and there were these privacy protections. And then the court ends on noting that in 2016, recent rulings by courts around the country events demonstrate a trend toward a more expansive understanding of sex in Title IX as inclusive of gender identity. It said, therefore, this court cannot say with confidence that the plaintiffs, the students who are not transgender and their parents, had a likelihood of success on the merits of their claim. So this is in 2016, a court saying, hey, there's a lot of court rulings that are trending in favor of transgender students, whether it's about their names or their use of bathrooms or locker rooms. That trend continued. Jennifer was just talking about, we have a 2016 ruling in the Sixth Circuit, so that's binding in Michigan. We have the 2017 ruling in the Whitaker versus Kenosha case, that's Seventh Circuit, that's in Wisconsin. We have the Bostock case, which even though it applies to employment, it's still an understanding of sex as inclusive of gender identity. So this was, sort of a premonition, very true. Then in 2018, a similar group of students and parents who are not transgender, you'll see the term cisgender thrown around as to refer to people who are not transgender. And in that situation, they again sought an injunction. So they sought a court order requesting the school to bar transgender students from accessing restrooms and locker rooms consistent with their gender identity. And the court in this case, and this is the Third Circuit, so this is in Pennsylvania. So we've got Illinois, we've got Pennsylvania. We're all across the nation here, pretty wide variety of states. Neither of these courts are particularly politically aligned one way or the other at that time. And in that case, the Third Circuit, again, says, no, we're denying your request for this order. You don't have any likelihood of success on the merits of any of your claims. And the Third Circuit says, we've already explained that the presence of transgender students in these spaces, bathrooms and locker rooms, does not offend anyone's constitutional right to privacy any more than the presence of cisgender students in these spaces. And it goes further. The court says, adopting the appellant's position would very publicly brand all transgender students with a scarlet T. They should not have to endure that as the price of attending public school. This case was appealed to the U.S. Supreme Court in 2019, but the US Supreme Court declined to take up that case. So the US Supreme Court in 2019 already is predominantly more conservative justices, but it declined to take up the transgender student bathroom issue in 2019. So then we get on to, I see that there is a question in the chat about transgender student athletics. I'm going to talk about that before we get into employee stuff, but after we finish bathroom. So we will get to it. So after this Parents for after the 2018 case, there's been a 2020 case with this Parents for Privacy group, again, where they do not succeed. The court and the Ninth Circuit says a policy that allows transgender students to use school bathrooms and locker rooms that match their gender, their self-identified gender, in the same manner that cisgender students use those facilities does not infringe on cisgender students' 14th Amendment privacy rights, doesn't infringe on parental rights or First Amendment free exercise rights, nor does it create actionable sexual harassment under Title IX. That case also gets appealed to the US Supreme Court, and they say no. It says denies cert on our slide there. What that means is, because of course, for lawyers and legal stuff, everything has to be in Latin. In order to get your case heard by the US Supreme Court, you have to file what's called a writ of certiorari. And so the Supreme Court, they get to read all these applications and basically say, oh yeah, we want to rule on this, we don't want to rule on this. So they had to read an appeal from the Parents for Privacy and say, nope, we don't want to rule on this. We are leaving the Ninth Circuit's decision in place. So they left the Ninth Circuit's decision in place and they left the Third Circuit's decision in place in 2018. Then we get to our most recent case, 11th Circuit, December of 2022, so just about 8 months ago. This is a case from Florida. This is a school policy, so not a specific student in this case. This is a school policy that separated student bathrooms based on students, and this is in quotes because this is the wording of the policy, biological sex, as that was established on the student's enrollment documents. This policy excluded transgender students from using bathrooms that corresponded with their gender identities. The 11th Circuit said, no, this policy does not violate Title IX or the Equal Protection Clause. It said this policy advances an important governmental objective, protecting student privacy. But the dissent in that case pointed out some questions that it had regarding the decision. It said, well, if we rely on the sex assigned at birth, what about a student's chromosomal makeup or other physical chromosomal makeup? How do we address that? What if we have students who are XXY or XYY? So their biological sex established at birth, how do we deal with intersex students? And then the dissent also asked, what about other physical characteristics? Those might be based on gender stereotypes, but they might be biological. And the question remains, how do we characterize all of these students? How do we say which bathroom they have to go to? The dissent also pointed out in a discussion we've had internally is, if it's based on a student's enrollment documents, a student could hypothetically transition in 9th or 10th grade, enroll at the school in 11th grade, and then be a transgender student who hasn't had any sort of sex change operation or any sort of operation on their body or their genitals. And technically, their enrollment documents would allow them to be in a bathroom that is different than their sex assigned at birth, but is consistent with their sex established on their enrollment documents. So there's some questions about kind of the practical application of that policy. What's our takeaway from this decision? It exists, absolutely. It is a circuit court decision from the 11th Circuit. There are 13 federal circuits in the United States, but this is not binding in Michigan. The 11th Circuit is Florida and maybe I think parts of Georgia. It is not Michigan. Michigan is the 6th Circuit. This conflicts with decisions by other federal appellate courts. Today, we've talked about a 6th Circuit decision, we've talked about a 3rd Circuit decision, a 4th Circuit decision, an 8th and a 9th Circuit decision. So of the 13 federal circuits, 5 others have addressed this issue and come down in a different way than this court did. So here that's where we have this internal conflict. And that's why we think, as we note here on the bottom, review by the Supreme Court is possible. Because the Supreme Court typically does take cases where there is what we call a circuit split, where one circuit says X and the other circuit says Y, and they are polar opposites of each other. So now that we have this 11th Circuit ruling, this is what makes it more likely that the US Supreme Court potentially takes up this question now after having kind of kicked the can down the road a little bit after the Grimm case. Okay, so let's jump to employee accommodations slide, but I want to address the question. I have a transgender male student who asked which track team, girl or boy, they would be on. I'm assuming the answer is the boys' track team. So this is a great question because we have a transgender male student. So that student's sex assigned at birth was female. Under Michigan law from like 1972, I think, or something like that. Michigan's in the revised school code, it says that female students can participate in any sport. And that was in order to ensure that if the school didn't offer girls soccer, they could try out for the boys soccer team. So the revised school code would allow this student, even if they weren't transgender, to try out for the boys team likely. And then where we're looking at transgender students participating in athletics, the assumption there is correct. Generally, you are going to allow the student to participate in athletics consistent with their gender identity. Get a lot of questions about how do we make that work? What do we do with MHSAA? MHSAA has their own process. They're going to reach out to them and say, hey, we've got a transgender student. What they will do is send back to you a FERPA release consent form, a form for the parent to fill out and a form for the school to fill out. MHSAA is like weirdly secretive about this, so they don't post any of this stuff on their website, but I've gone through this with a handful of clients now. So they basically send you a questionnaire that says, how long has this student been using this different name? What bathrooms are they using? Basically, how is the student presenting to kind of look at trying to make sure that the student isn't trying to use being transgender to participate in a sport and gain some sort of competitive advantage when they are not transgender. Yep. And so MHSAA has that paperwork. You submit that to them, and that's how they deal with it.
Yeah, I think they only, and you can double check with MHSAA, but my understanding is they only use that paperwork when it is a male to female transgender student. Yes. And so in this particular example, for a female to male transgender student, because biologically female students have the statutory right to try out for the boys team anytime they want, even if there is a girls team. My understanding is that MHSAA would not get involved in that. And Cristina is working on an answer to, I don't know what that paperwork is called.
I don't have a name for that paperwork, but when clients had a request for a transgender female student to participate in sports, that is what they got a copy of. Yep. Of MHSAA. So sorry that I can't help you. Like I said, MHSAA is a little bit, they hoard their information a little bit. Yep. Okay, so I want to try to briefly get to employee religious accommodations before we get to our end here. So this is, again, more hot off the press stuff. So the US Supreme Court in June of this year rules in a case called Groff versus DeJoy. This is where Title VII prohibits employment discrimination based on religion. We all know that. We know it's we can't discriminate against someone based on their religion. And we're required to make some accommodations. It's part of the First Amendment. We know that we're not supposed to do that. So in the Groff versus DeJoy case, it dealt with a U.S. Postal Service employee. The Postal Service started providing Sunday services in some places. This employee was an evangelical Christian, said, nope, I can't work on Sundays. And the U.S. Postal Service wasn't able to accommodate. So he had some unexcused absences, and then he received progressive discipline until he resigned. And there were hardships that the employer said that they would have had to endure for all these absences. They were having to rework schedules. There was disrupted workflow. There was diminished employee morale. And so the lower court said, yeah, that's enough to establish a de minimis undue hardship. So they're looking at a de minimis standard when it gets to the U.S. Supreme Court. U.S. Supreme Court says, no, it's not a de minimis standard. They say actually it's a substantial burden to demonstrate that it's an undue hardship. They say that this is a higher standard than de minimis. It's got to be a substantial burden to a school, to an employer, for them not to make the religious accommodation. And then the court talks about essentially considering what we do with ADA requests. And they started talking about using the interactive process, which is very similar, would be very similar to the accommodation interactive process under the ADA. Having the conversation with the employee where they might propose an accommodation, you might respond with a different one, and there would be sort of back and forth. Because this case just came down, and because today we're talking about so many different things, we could talk about employee accommodations for 3 hours, and our labor team, I think, is doing a presentation on that this fall. So I don't want to like get too deep into the weeds here on this, but the change is significant because in a case out of the Seventh Circuit called, I think it's Klug, I might be mispronouncing it, I apologize if I am, in April, so before the U.S. Postal Service Groff case comes down from the Supreme Court, we've got a teacher who objected based on their religion to a school's policy or practice of using a transgender student's chosen name. And 2 transgender students said that they were affected by this teacher's refusal to use their names. They complained, other staff and students complained. They said that this didn't work. The school tried for a year to allow him to use a student's last name. And the students said, oh, well, no, it's super obvious why we have to do that because that's the only class we have to do that in. So after the year, then they're saying, the school says, no, now you have to use the student's preferred name. The teacher ends up resigning. He says he was forced and coerced to resign because the school failed to accommodate his sincerely held religious beliefs. So the Seventh Circuit in April of 2023 says, no, we agree with the school. This would have been an undue hardship. They say allowing the teacher's requested accommodation would have imposed an undue hardship on the school's ability to provide an education to all students free from discrimination. But pump the brakes. Love using little sound effects there. When we get the Groff versus DeJoy decision, the Seventh Circuit issues a 1-page order that vacates. That means their decision is now, this April 2023 decision is now gone. It's them saying, nope, hey, the US Supreme Court just issued this new standard for religious accommodations that it needs to be this substantial burden rather than the de minimis burden. So we are going to vacate our opinion. We're going to send this case, remand means send this case back to the district court, so the court who had ruled on it before them, to say, you guys now have to take this new standard and you've got to apply it. It means they might have to reopen discovery. There might be testimony. This case could go on for a little bit before there's a decision about whether the teacher's requested accommodation of using only last names would impose an undue hardship under this new standard. So we don't know how that case is going to come out now that we have this new standard. So this is one of those like open questions where we had a court decision, but now we have another court decision. So it isn't, again, where Jennifer said we don't have that silver bullet, we definitely don't here. But this is something where with regard to the Supreme Court's decision, we do have a mandate from them saying, hey, it's got to be a substantial burden for it to be an undue hardship for you to make that religious accommodation. The last thing I want to touch on is parents' rights versus school policy. These are a couple cases that are from like circuit courts in Wisconsin and Massachusetts, but these are some of the first cases to try to address the sort of parents' rights versus students' rights issue. Again, they're not binding in Michigan. They are these circuit court decisions, so I don't know that they would even be considered persuasive by a federal court, but they exist, so we put them on your radar. Doe versus the Madison Metropolitan School District case. Madison Metropolitan School District chose to adopt a school policy, so an explicit policy, written policy, that prohibited staff from disclosing student gender identity to parents without student consent unless it was legally required. That case, that got dismissed because the court said, hey, no, you don't have standing, you don't have a reason to move forward on this because you're saying you don't think the policy is right, but you don't have an actual student who's been harmed by this yet. So they dismissed that case, but it's likely that that will continue to be challenged. Then a school had a similar policy in the Foote versus the Town of Ludlow case in Massachusetts. So again, a similar written policy that says, no, you can't disclose students' gender identity. Court finds in the school's favor, but says something that I think we would agree with as school attorneys, which is the student and parent would almost certainly be better served by a more thoughtful policy that facilitated a supportive and safe disclosure by the student. And that aligns up with exactly what Jennifer was saying before, which is we don't want you to be in the position where you're keeping information from parents because it extinguishes the trust that you have. Those kids are going to be in your school for a long time. We want to try to have everyone involved. And if you look at that SBE guidance that Jennifer was talking about, the SBE guidance, even though it's citing to statistics from 2016, those statistics remain consistent. Talks about how if a student, and LGBTQ students, not even just transgender, but lesbian, gay, bisexual, transgender, queer, gender fluid, anything like that, those students are something like 5 to 10 times more likely to engage in self-harm or suicidal ideation if they're not supported at home and at school. And so where we can get everyone, at the very least, on the same page, then we're moving in the right direction to help make sure the kid gets their education and they stay safe, which is just your main prerogative. And that is our presentation. And we're exactly at 1 p.m.
Yep. And I don't think we have any more questions that have popped up. Just to put a couple things on your radar, these are, we do continue to see some litigation in this area. There was some filed earlier this week. I'm also aware of at least a threat by the ACLU to file an MD Michigan Department of Civil Rights complaint in a district. So we expect this will continue to be litigated. We often write on this topic in our monthly school law notes, and to keep everybody apprised of new developments in this area. As we mentioned at the beginning, we expect we might get some additional guidance in the Title IX regulations that are coming out in October. We'll see. But stay tuned, because this is something that we know will continue to evolve. We also know it's a hot button issue. So if you guys need help, please give us a call. We can help talk you through just about anything. And we might not have all the answers, but we can probably provide you with some tips to help.
Jennifer and Christina, I just want to thank you both so much. I have absolutely no idea how you did that in an hour, because as you were going, I thought, oh my gosh, this could be a 3-hour thing. There's just so many details with it. But as Nicole noted, she's looking forward to getting this email for future reference. And it is kind of something that you're probably going to want to revisit, or as a situation comes up, just kind of keep this, filed somewhere that you could come back to it. Just make sure that you're kind of on the right track. So you will be getting this within 24 hours, along with a handout that Thrun has also provided. So thank you, ladies, once again. I know your schedules are super busy, and we appreciate it. MASSP does also have some other upcoming webinars. As you know, there is a digital transition this year with PSAT and SAT going fully digital. So if you haven't been watching that webinar series, we do have the first couple recorded. Part 3 will be coming up September 12th. We also have an introduction to esports in the Michigan High School Esports League. So if you've been thinking about that, we have a webinar coming up. And also on September 20th, for those of you that are maybe new to administration and have not gotten a lot of training on proper interview techniques, we have one of our most popular webinars that is scheduled for September 20th on that topic. So that's everything that we've got going on. We appreciate all of you. Have a great rest of your day.
Thank you.
Thanks, everybody.